Trauma. Everyone has it. No one talks about it. It seems easier to stay silent, ignore it, or stuff it than it does to honor it, learn from it, and finally heal. Trauma is debilitating, yet so often we suffer in silence. Trauma is not meant to be battled alone, and we are no longer going to suffer in silence. Together, we are creating a safe place to speak, to share our stories, and grow our strength as we heal. Together, we are giving a voice to those who have been silenced, bringing darkness into light, and letting God use our stories. Today, we find ourselves again. We relight our spark and let it light up the world. Stop SIS is a nonprofit organization dedicated to educating on issues of trauma and trafficking, as well as the amazing power of the healing journey. Welcome to Stop SIS. Hey, you guys. Welcome back to Stop Suffering in Silence. My name is Denise Walsh. I'm here with my friend Rachel Timothy. And today we have a really, really special guest. Last week, you heard that Rachel's lawsuit has been filed. And really, that is about all we could say. We really can't talk much about the case specifically. Ongoing cases you have to be careful. But we have a friend who could. So our guest is actually Rachel's lawyer on this specific lawsuit. His firm is called the Mahoney Law Firm. He works out of Illinois. And over the past 16 years has brazed a trail for himself and survivors to get justice. Just a few of his accolades. He's been named the top 40 under 40. He's been named the top 100 trial lawyers and is leading the charge for survivors to get justice. And we're just grateful to have him here to pick his brain, not only about Rachel's story and specific case, but also really about you and what you can do if you're a survivor and are interested in learning more about how you may be able to get justice too. So thank you, Ryan, for being with us today.
Thank you, Denise.
Okay, so how do you say your last name?
Mahoney.
Mahoney. Okay. Mahoney Law Firm from Illinois. Look it up.
Yes.
Okay. The link will be below as well. Before we jump into Rachel's story and specific survivor cases, I'd love to hear a bit about your story and why you were drawn into law, and then why you were drawn into this specific type of law.
Well, I am not an Illinois native. I grew up in Fargo, North Dakota, believe it or not, and come from a family of people who provide services to the community, not only in politics, but in medicine and things of that nature. So my father's a physician. My siblings are PhDs, oddly enough, specializing in sexual assault. So I was in college, went out to Washington, D.C. and worked for a senator. And at the time, I think I was enjoying the college life too much and thought to myself when I met these leaders of the world that this doesn't seem too hard. I should maybe take this more serious and I can do something to change the world too. So came back from college, went to law school, decided, like every law student, that I'm going to make a difference. You get into the real world and realize not quite that simple. But over the course of time, I started developing a practice in sexual harassment in the workplace, and represented many women and men who had been sexually harassed in the workplace. And you hear the most horrific stories, and you wouldn't believe this stuff happens still in America, certainly today. Well, during the course of that, I became a girl dad. And being a girl dad, you sit there and go, especially when you're a lawyer, that, all right, I have 18 years to fix this world before she's out there in it. I don't know if that's possible, but hey, if all of us are trying that, maybe we'll get there. Well, during the course of this practice, I started meeting survivors, victims of sexual assaults, not only in the workplace, but everywhere. And a woman came into my office about 8 years ago now, who was distraught. No one could help her. No lawyers would take her case. And her teenage daughter, who had special needs, had been harmed at school when she was taken out of class, and some boys assaulted her in a closet. Now, majority of cases against schools in every state, schools have protections. The law has woven in immunities that make it very difficult for you to hold the school accountable for situations just like that. So most lawyers turn that case down because they go, we can't hold the school liable for that. She walked out of my office and I just said to myself, I have to help her. I'll try whatever I can do. Well, 40 plus depositions later and fighting motions and everything else, we finally get her case to trial and ended up with a very good result for there. And from then I was hooked, because there was many people out there like her and like Rachel's story that I think everyone's familiar with. And these people need a voice, and they need someone who's not afraid to fight a fight that could be a losing battle. But at the end of the day, it's very rewarding. Mm. And now it's almost, we get calls weekly, daily, with survivors all over the country. Can't help everybody, but we try. We try to find a way for them to share their story, for them to get some semblance of justice, which for most is a very difficult reality to even think about.
Sure. So are sexual assault cases the primary case that you take on these days? Yes.
And it ranges from in the workplace, in a premises setting like a hotel, going out at night, you're in the club, women are assaulted all the time. And then the one that is probably I'm most passionate about is childhood sexual abuse. Mm-hmm. Children cannot explain what is happening. They don't know what is happening. And someday they figure that out, and it's horribly traumatic. And those are the ones I'm really passionate about. And that is a very, there's many legal issues entwined in that, because you're talking about many years over time, but we can talk a little bit today about how many of your listeners and subscribers can maybe come forward.
Yeah, let's talk about that. So I think one thing that we've as an outsider, you think, oh, when somebody gets assaulted, you immediately go to the police. And then justice is started, right? Well, we know that that's not always the case, and probably not the typical case, because if somebody gets assaulted, they have to go home and heal, and they're in freak out mode and they're in shock, and it doesn't. And sometimes, like in Rachel's case, these memories are buried until the flashbacks come. And so by the time a survivor is potentially ready, they may wonder if it's too late. So what do the time frames look like these days?
So I'm going to agree with you in some respects. If you feel brave enough to come forward and tell the police, you should, because you're creating a record of it right away. And also, if there's been any type of assault that involves penetration, you should go to the hospital and have a rape kit done. That absolutely should be done if you can. I realize that doesn't happen a lot. The problem is, sexual assault cases are not prosecuted very often by our state prosecutors and our federal prosecutors, bless you. And because of that, and it's mainly because it's, in their mind, a he said, she said situation. And because of that, they're not willing to prosecute. Well, in the criminal setting, which everyone should understand, is those prosecutors have a burden of proof. It's not really their fault, but that burden of proof is beyond a reasonable doubt. Beyond a reasonable doubt is 100% convinced. We have to know 100% this happened in order to convict this individual. And that's often why sex crimes are never prosecuted. Now, civil is much different. In the civil context, the burden of proof, and that's the burden we as attorneys have to show to the jury that we're more likely right than wrong. Well, that more likely right than wrong standard is 50.1%. So do you have enough evidence to show the jury that you're more likely right than wrong? And that's why people should think about talking to a civil attorney, because you do have a chance at justice. And you do have a chance to hold the wrongdoers accountable, or that's not always the case in the criminal context. There's also different statutes of limitations, which I can talk about as well. But in the criminal context, it's often you're getting a lot of shut doors. And I think many who are listening to this would agree with that.
And that's in the criminal context with the like burden of proof being 99% sure, like we've got tangible physical evidence is oftentimes what they're looking for, which is why going to the hospital and getting a rape kit or DNA or things like that is really important at the beginning if you can.
Right. And the hard part is, though, too, is when we're talking about childhood sexual abuse, how is that child going to know any of these things, right? Or to know that anything's wrong? The stories I've heard about children describing this to their parents, only a parent would really know something's wrong. You know, my child doesn't say those words. My child hasn't seen those things, right? So it's very difficult, and it's just often, unless someone admits it, which is very rare. You know, we swear on the Bible under oath when we testify, but people lie. I hate to tell you, people lie, and it's to save their own butts, right? But I'm a firm believer, maybe I believe too much, but survivors, victims of this type of conduct, they have one truth, and they have the truth of what happened. Their truth never changes. Liars have many different stories, and we usually figure that out.
Yeah. So what is the statute of limitations these days? And is it different for criminal versus civil?
It is. So criminal, there's federal law for criminal is usually 3 to 10 years for criminal charges to be brought. Our government's working on that. We'll see what happens. States differ. Every state's different. I couldn't sit here and tell you all 50 states what they are. But in most contexts, by the time you're realizing perhaps that you were a victim of sexual abuse as a child, it's often too late. That's why civil is your secondary option. Now, I practice primarily in the state of Illinois. There's a Childhood Sexual Abuse Act here that allows mostly adults, right? Because you're coming to terms with this as an adult. It allows 20 years from the date you realize you were a victim of sexual abuse to bring a lawsuit against all the wrongdoers. Our federal government enacted a law on September 16, 2022, and it's a long one. I wrote it down. Eliminating Limits to Justice for Child Sex Abuse Victims Act of 2022. Wow, that's a lot. Right? That eliminates the statute of limitations for people to bring a lawsuit for sexual abuse or sex trafficking, any type of sex type of crime, for federal laws. So for federal causes of action. Remember, we have two different areas here. We have federal law and we have state law. And so there's different types of causes of action you can bring under federal law and that you can bring under state law. Well, the federal government has said there's no more statute of limitations. However, I want everyone to know that this isn't retroactive. So if your case was already expired, it doesn't get reopened. But if your case is still active, meaning the statute of limitations is not expired, this new federal law says you now can file it in perpetuity whenever you feel brave enough to come forward.
Wow.
Yes.
Wow. So if somebody would be interested in going after getting justice for their perpetrator, it sounds like you're not just suing the perpetrator, but there also could be other people involved in the situation that could be a part of the what is it called, complaint or
complaint, cause of action.
Okay.
So yes, and Denise, and often the stories I hear are, this is who I call them bad guys, get the bad guys. So this is who the bad guy was. This is who did it. My job as a lawyer and any attorney out there is to help you figure out who else is culpable here. When we're talking about a case where we have abuse in schools, all right, it's not just the teacher or the administrator or the coach or whoever did something to you. Oh, I have cases that are student on student, okay? It's who failed somewhere to allow this to happen. And sometimes maybe it's nobody. And that's what we got to figure out. But sometimes, some cases, administration, principals, the teachers, they are all aware that either a student or a teacher is a problem and they fail to do anything. And that's what we want to look at, because in the civil justice system, we can't put people in jail. And maybe we get lucky and they'll admit something and we can reopen a criminal case against them. But in the civil context, justice is recovering money to attempt to fairly compensate the plaintiff. Now, I would argue to you there's no amount of money that could fairly compensate a survivor, because those type of injuries are always there. I do personal injury cases as well, and it's much easier to show a jury a broken arm and a surgery, and that's how much it costs, and now it's fixed, and there's your scar. That's what you should pay. But what about the scars we can't see? What about the injuries we can't heal, that we only learn how to cope with and live with? What is that worth? I'd argue there's no number, but I'm very biased. But that is the civil justice system. The civil justice system is money. The way you hold people and corporations accountable is to make them pay. Because if they pay, this behavior will stop happening. And that's the idea. But in the context of schools or municipalities or groups like that, you got to thread the needle, because they have these immunities and protections. You can't just say you were negligent, you should have done something. It has to be a reckless disregard for the safety of that child. And that's a different standard. We call it willful and wanton. Almost intentional, not quite intentional. That's where you knew or should have known that the failure to act could cause serious and real harm. And when you're dealing with a case that's sometimes 30 years old, 20 years old, those things aren't always easy. But there's a way. And if you're brave enough to come forward, if there's a way, we'll find it.
So go ahead, Rachel.
Well, and I hope this is okay to say, but I know for me, money's hard for me.
Mhm.
And so this was a hard decision. But whenever I realized that this is how people change their behaviors, and this is how I can know that kids are going to be more likely to be protected and cared for in the right way in the school system, like that is what, I mean, that's what did it for me, because that's what needs to change.
Right. And yes, it's a hard thing to think about is, I just want accountability, not necessarily money. I want accountability.
Yes.
But if you actually want to affect change, people have to pay. There's something in the legal system called punitive damages. It's not available in every case, but what it is designed to do is to punish and deter future similar behavior. Well, when you have to pay out large sums of money, it tends to curb future behavior. You tighten the strings on your policies and procedures. If you see something, you say something. You know, all sorts of things that can be done where children across America are not being harmed, while we go, well, he would never do something like that. Or that's how he is with all the students. I know him from my church. He doesn't act that way. Open your eyes.
So as a lawyer, do you turn into a detective then to go find that evidence or look through things or interview people? Like how do you have time for that?
That's the tough question. How do you have time for that?
Yeah. Like how does that work?
You're definitely an investigator, but you need help. You know, I have a very strong team here of people I trust that help me. Sometimes in big cases that have many layers, you have to hire a private investigator. It's going to go out and interview people and get statements. Law enforcement is sometimes helpful. That's why I say you should report it, because they'll go out and interview people and talk to people and get into doors that we can't get into as attorneys. So you just peel back that onion layer after layer and try to learn as much as you can. At the end of the day, your strongest witness is your plaintiff. Your strongest witness, and when I say plaintiff, so everyone knows, that's the person bringing the case. So your strongest person is your plaintiff, because you start there. I don't think many people are coming forward 30 years later to bring a lawsuit because they're making something up. That doesn't happen. All right. And that doesn't happen with people that have suffered trauma, like many who I've met have suffered trauma. So you start there and then you ask, who do you know? Who saw something? Who are your teachers? Who are your friends? Who do you go to church with? Who knows something? And by the way, This isn't just a message to those out there that are survivors. This is a message to all those out there that can help survivors. Don't be afraid to come forward and help. You should not live your life thinking I could have helped that person or I should have said something. You can really change their lives.
2 reasons why it feels like somebody might be hesitant. Well, there's a lot of reasons, right? That somebody might be hesitant to come forward. It's re-traumatizing, the fear of not being believed again, those types of things can keep people small. But also the idea of going to trial. Tell us a little bit about what trial looks like and what would be required of the survivor potentially. And I'm sure it's different in all cases. But if a case were to go to trial, what does that really look like? And how often does it happen? Do people settle first? I don't know.
You're just like a lawyer, Denise. You have 6 questions in one.
I do. Tell me everything.
Yeah. So I tell all my clients that you have 3 phases that I need your help with. All right. The first phase of any lawsuit is written discovery. This is where we exchange information and documents. And guess what? You're going to have to help the attorney answer written questions. And yes, you have to go through some of the stuff that's hard to talk about, but it's just you working with your attorney and your team. Okay. So now the other side, they have to give us information and documents too. So it's a give and take. The stuff you see on TV where you get to trial and there's some smoking gun document no one's seen before, that never happens. Because guess what? The judge is going barred. If you didn't give that document to the other side, then you're not going to be able to show the jury now. So that's phase 1 is written discovery. The second phase, which is often the most difficult for any plaintiff, is providing your deposition. Because to the last question you had, Denise, they've done studies, 94, 95% of cases settle before trial and never go to trial. But you're very likely going to give a deposition. And what's a deposition? A deposition is where the attorney for the bad guys gets to ask you questions about what happened. Under oath, with a court reporter typing down everything you say. They often video record it to make you feel uncomfortable. All right. But your lawyer is sitting right next to you, protecting you, making objections when appropriate, and has trained you and got you prepared for that thing. So you're going to do just fine. But that's often the most difficult part, because now you have to tell your story again. You have to tell it to a person you don't necessarily want to tell it to. And it's in an uncomfortable setting. But most of the time, that's the last time you have to do something like that. But if you do go to trial, this is what you should know. Trials like this can often take a week or 2 because there's so much to tell, right? I like to keep my trials short, but the defense doesn't. The defense wants to drag it out. All right. The defense is hoping you'll do or say something that'll harm you. But what it looks like is you go out there, and majority of the time, you as the client are just sitting at the table and trying not to make a face. Because you're going to hear people say things, and you're going to want to, scream, shout, punch a wall, and you got to sit there and act like nothing's wrong because the jury's staring at you. They're not watching the person talking. They're like, ooh, how's Rachel going to react to what he just said?
Okay, but I have a terrible poker face, just so you know.
We'll work on it.
Okay.
You're going to get there. But majority of a trial, your attorney is doing all the work. But again, if you go to trial, there will come a time where you have to testify. And you will have 12 strangers looking at you, judging you, and you got to tell that story. And I don't say that to scare anybody. I just say that to you to know that this is America. I mean, we have social media. People judge you just by your profile page. So if you don't think they're going to judge you just by how you look, dress, and appear, you're wrong. They do. All right. Now, the hope is we picked a jury of your peers and people that will understand you and believe your story and award you just compensation. But the defense gets a few of their people too on there, right? So in that period of time, me as your lawyer, I get to ask you all the questions. I get to tell your story the way we want to tell it. The defense then gets to cross-examine you about what you testified to. That's probably the most difficult part in any case. If you get there, remember, 5% chance that's ever going to happen. And if it happens, they're going to cross-examine. Yes, Rachel.
Will the defendant be in the room in these cases?
At trial, they have a right to be there. However, I will tell you, in these cases, majority of the time, we ask the court for a protective order. And here's why. In any case, a party has the right to appear at a deposition, at trial and be present. So if you think about deposition, if you have your abuser sitting across the table from you, imagine how traumatic that is. So we go to the court, and often we'll have the assistance of a therapist or psychiatrist who's been treating you and say, look, judge, this would be horribly traumatizing for this person to be in the room. We need a protective order so that they're not allowed to be there or be present. And anytime these things happen, and 9 times out of 10, that's granted. Because at the end of the day, do you need to be there other than to intimidate the witness? Right. And the way we are today with Zoom and all these things we can do, I take most of my depositions just like this, like we're doing right now, not even in the same room. And at the worst case, we say, Judge, Mr. Bad Guy can listen on the phone 1,000 miles away, but he doesn't need to say anything. He doesn't need to be there. And we don't need the plaintiff to be in contact with him. So that's what we do in most of those cases. So you're going to be sheltered. You're going to be, in a cocoon, in a bubble throughout the entire case. Whether your attorney's me or someone else, we are very aware of what this is doing to you, and we're making sure that you're protected best we can. Trial, a little bit different story. Trial, it's important you're there. It's important the jury knows it's important to you. Now, sometimes if it's a really long trial, we won't have you there every day. It gets to be long, and sometimes there's stuff you just don't need to see or witness or go through again. But at the end of the day, you're as much a part of the team as your lawyer is.
Is it typical for the defendant to take the stand and testify?
It's hit or miss. Sometimes, there's something called, I think everyone's heard the Fifth Amendment. I plead the Fifth. A lot of times in these cases, the defendant will plead the Fifth because they're concerned they'll say something incriminating, which would reopen a possible prosecution. Now, when many of these cases are beyond the criminal statute of limitations, they're not afraid to say anything. So they'll get up and testify. I never did this. I'm a pastor at my church, and I'm the best person that was ever put on this earth. And by the time they're taking the stand, the whole jury is like this. Don't believe a word they're saying because the Rachels of the world have already told them the truth.
Mm-hmm.
So that's how I look at it. I'll take them any day. Do you want to get on the stand and talk about how you didn't abuse a child? All right, let's see how that goes for you, buddy. So, sorry.
So they may not choose to have the defendant speak, but they could certainly.
They could. They have the right. Any person in America, if you're sued, you have the right to defend yourself. You have the right to set forth any defenses you have to the case. The right to tell your side of the story, right? The defense attorney usually will tell the jury first thing in their opening statement. There's always 2 sides to every story. I always say, yeah, but there's only one of them that's true. So
like your side is inappropriate and wrong and evil, sir. So there's no justification at all.
Well, right. And doing what you two do and the help you're providing survivors, I'm sure you've looked at some of these studies and stuff. Children don't lie about this stuff. Children don't have the vocabulary for many of this stuff. And once you become an adult, I really struggle with what would be the motivation to come forward and go through these things. The lawsuit I just described to you, if you weren't telling the truth, I struggle with that because I just am not a believer that happens in the world. At least not the clients I represent.
Well,
now
why would you pay a ton of money to go to counseling for however many years to try to help yourself through something that didn't happen?
Right.
It doesn't even make sense.
Yep. And they, and you can read a number of studies on this. I was telling you earlier, I have siblings in this world and they send me publications. There's a great book out there, The Body Keeps the Score. It talks about some of these things. And I just think it's highly unlikely in the context of childhood sexual abuse that it is not your truth.
Random question. Are you able to utilize like old journals or old pictures or old writings or anything like that somebody may have had from?
Yes.
So if they wrote about it in a 1989 journal and potentially have it in their basement, it could be helpful.
Yes. So there's, not that we're going law school on you guys today, but there's something called foundation. Can you lay foundation for a document? Who created it? when, where, how, like why. And if the individual can say, I'm making this up, at the age of 10 years old, I used to journal about what was happening to me. I wrote the date on the page every day. Some days was just about, there's chicken nuggets at school. Other days was about what the bad guy did. Yes, it can come in. It provides you credibility. It's not evidence that it happened, but it certainly provides credibility to you, to your story, that this did happen, especially when the person on the other side is going, nope, never touched her.
Now, one thing I'll recommend, and you can let me know what you think, is to make copies of everything and not to just give your journal to the police or to whoever, because that's evidence you might want again down the road, and you want to make sure you still have it in your possession. Correct.
In fact, we have a rule in our office: if you give me originals, you have to wait till I copy them, and I'm giving you the originals back. I don't like to keep them. Phones is also a really big thing, especially when you have a person that's intimidating you and trying to keep you from coming forward. You want to try to download everything on your phone to some sort of backup service before you turn it over to the police. I've seen horrible stories where we lost the phone. We don't know where it is, or we somehow wiped it. You did? I mean, your job is to
you have one job.
Okay, so what happens if you do give your journals to the police and they haven't given them back to you yet?
Well, maybe you know a lawyer that can subpoena it and get it back.
Do they destroy those things?
Often not. I mean, every place like that has a retention policy of how long they retain these things. But there's probably a locker somewhere with that in it.
Okay.
If we're talking about a hypothetical person. So during the course of a lawsuit, you get everything. Like once you file a lawsuit, you get subpoena power. So that's where, court signs a subpoena saying you get what you're requesting, unless it's way out of bounds, right? So we can go to law enforcement, we can go to the FBI, we can go to places that have these documents and get them. Now, public agencies like the police department, they have to turn over certain documents pursuant to a FOIA request, Freedom of Information Act. But a lot of it gets redacted or whatnot when it's talking about these type of cases, especially in the case of a minor. Case of a minor, they often won't release it without a court order. So
one question I have is about protecting the name of the survivor. Again, I think sometimes it feels like, oh my gosh, I'm going to be on the Today Show or something, and like, I don't want that. I don't want people to know. Is there a way to go through this process without it becoming super public or protecting your privacy a bit?
Yes. I would say majority of my cases are filed as Jane Doe. And the law universally recognized that the name of the victim deserves protection. In very rare cases, that can be undone, but normally it's in cases where the judge is ordering you to turn over the information to the other side so they know what they're defending. But most courts, most judges recognize that survivors, victims in cases like this, their names deserve protection. So what we look like is Jane Doe versus School District 143, right? Rachel's case. Rachel was brave enough to put her name on it. That's not always the case. But as everyone listening knows, Rachel's a unique person. Rachel's written a book. Rachel's been on your show. Rachel's been on many podcast shows, writings. She's all over. She's telling her truth, and that's okay. But not every person's built that way, and we totally understand it. Sometimes you want justice and accountability, but not the attention that comes with it. It's one thing to shine a light on the bad guys, right? But it's another thing is like, I don't want that light shined on me too. I just want people to know what they did. I kind of have this phrase I talk about around the office is my clients have to live with this. So should they. And they should not be able to go through their lives with no one ever knowing what they did. And part of filing a lawsuit is shining a light on that. But you also have to have a reasonable basis and a purpose beyond just, opening the door to what they did. You also want to go the full way, get justice, accountability.
Have you found that starting with the civil case has ever led to a criminal case when all of like within the discovery period, there's enough evidence, or typically it's been too long for there to be some physical residue or connection?
One where it's been decades, it's very difficult. Others, I'm usually in constant contact with the local state's attorney, and we'll take a deposition or something like that, and they'll ask me to share it with them. They likewise will share me their investigation file, because you both have a unified interest here. Was there a crime? If there was a crime committed, we want to prosecute it. Again, remember that burden of proof, though. It's different. So short of you getting an admission or some smoking gun document, photograph, video, they're still going to be reluctant to prosecute. But if, for example, let's use the federal criminal statute of limitations of 10 years. Oftentimes I represent young ladies who have just turned 18, and this happened a few years ago. We're still within that 10 years. So we're hopeful that we get some information or evidence that the state's attorney will go forward with it. It's hard when it's student on student, child on child abuse, because that kind of cuts both ways in terms of do they really know what they're saying, or do they have the capacity to admit doing something like this? So I still think even in those contexts, they're reluctant. And I got to tell you, that's even scarier, because I had a case once where it was teenager on teenager, and the young man was prosecuted as a juvenile. Well, guess what? When you turn adult, juvenile records are sealed. So you have a sexual predator out there who's, to the world, no different than anyone else. Those type of laws, I think we can work on.
Wow. Is there any other question that you get from survivors that you think we should address and make sure we share today?
Is this even worth it? Get that all the time. What's this gonna do for me? Anything. And I think for every survivor, that's different. I think there's a real healing, because I've seen it. I think Rachel can tell you about it, and seeking accountability. I think it helps. I think it strengthens you. I think to fight back and to have someone in your corner fighting for you is a feeling many of your survivors have never felt before. And I think if nothing else, even if the case goes forward and we can't win it, that will help you. It's worth it.
I agree. I can't remember. It might have been The Body Keeps the Score, or some book that I read that talked about how the importance of fighting for yourself. And for a long time, like I have shared my story, and I have gone into police stations, and I have done a lot of different things. But back then I was still kind of just following what I thought was the right thing to do. It wasn't really me taking charge. And now that I've healed a lot and I'm doing so much better, it's like I'm able to fight for myself, and this is my way of doing it. And so the book, The Body Keeps the Score, I think is where it talked about like Hurricane Katrina, and the people who rescued themselves are the ones who had less PTSD, less traumatic struggles, versus the ones who had to be carried out. And so this is my chance to say, no, like this was wrong. I'm fighting for myself, and then I can stand up for other people so it doesn't happen to them too.
Mm-hmm. And I think that's a big part of it too, Rachel. You and I've talked about that, is helping others that come after you.
Yeah.
Right? Many of these predators, you're not their only victim. You're not the only person they've done this to. And when you shine a light on the rats, they scatter. And so what we got to do is bring these things to light. I believe that we should be able to Google their name and that comes up, because guess what? You did it. And everyone needs to know you did it. These are not people that should be leaders in our community. These are not people that should be around children. Hopefully no one thinks that's harsh, but it's the reality. I mean,
correct.
If they're not in prison, they shouldn't be around other people they can harm.
Part of the grief cycle, right? Grief is up and down. It's not like a linear line, but once the final stage, the most healing stage of the grief cycle is creating meaning and giving back to those who are 3 steps behind you. Mm-hmm. And so I feel like this pursuit of justice is a way to say, like, this isn't right that this happened to me. And now I'm going to do what I can to make sure that other people don't experience this as well. And it's a true healing. It's a part of the healing process.
Mm-hmm. Yeah. And you two probably know a lot more about that than I do, but I do think that I've seen it in my clients' eyes the day that either they get a settlement or a jury returns a verdict, because to them, someone believed me, and someone is holding them accountable for what happened to me. And those looks that I get are why I do it.
I've got a couple questions left, and then but one of them is there another option between settling and trial?
Well, in the civil context, not a result you'd like. So in the civil context, you can walk away from your case at any time, but you're not going to get money for that when you risk never being able to bring your case again. And in every one of these cases, especially when there's a very long time frame, the defense is going to fight tooth and nail. They're going to file motions to dismiss. They're going to say your statute of limitations blown. Sorry that this happened to you, but you can't bring a case now. So there really is no other option to getting justice other than a jury verdict or a settlement, because any other option means they won or you decided, I can't do this, I got to walk away, which happens. It's okay. And sometimes we'll get into a case and I have clients that are like, I can't do this. I thought I could, I can't. And it happens very rarely, but it does. But usually I'm pushing you. I'm saying, don't you worry. You're not doing this. I am. Just help me with information. We'll be okay. And we get there. But generally, that's the only way, is a settlement or a verdict. And people should keep in mind, I'm not allowed to ever say this to a jury, but these entities, these groups, these companies, these schools, they have insurance. You are not bankrupting a town. You are not bankrupting a school district. They have insurance. That's who we're talking with about negotiating a settlement.
That was huge for me.
Mm-hmm.
I know that.
Yeah.
That's a big one. Now, the law doesn't let us tell the jury about insurance. No one's allowed to tell the jury about insurance. So oftentimes everyone should know, your jurors are thinking, are my taxes going to go up if I hit this school district with a big verdict? Which is, I think, a little unfair, because that shouldn't come into their mind. But it's part of it. But some of the bigger school districts, it varies, right? You got a smaller school district on what the policy levels are. But that's generally who you're negotiating with to get money for survivor.
And I know you've also mentioned hotels or other groups there's more than just the perpetrator that could potentially be on the lawsuit. And I think that's really interesting for people to know. Yes.
And Denise, you raised a good point. And I know we're kind of going along here, but there's sex trafficking. I think we all are familiar with that term. Some lawyers in recent years have started bringing cases against hotel chains, gas stations, places that allow this to happen and are making money off of it. They're aware of it's happening. They're making money off it. And they've been able to prove and go after certain hotels and things like that, showing you knew, you allowed to happen, now you're going to pay for it. So don't think because I was trafficked in a hotel or at a gas station, I have no recourse because I don't even know who these people are. You know where it happened at, and that's a start.
Yep.
Rachel, is there anything that you want to ask or end with?
Just a huge thank you for being willing to be on here and speak all of this, for being willing to be my lawyer and be my voice.
Of course.
I'm not going to cry right now, but I might. It means a lot that somebody believes me and standing with me in this fight. I have my army and you were added to it. So I appreciate you.
Thank you. And I'll say to anyone out there, if you know anything about Rachel's story, about where she grew up or anything else, and you know something about it, don't be afraid to come forward. You want to know how you can help Rachel and other survivors? Be brave. Share a part of their story.
Yeah. How would they get in touch with you? Just go to your website?
Yep. You can contact me at my website. It's themahoneyLawFirm.com. We also have a Facebook page you can reach out to us at, Mahoney Law Firm LLC. Generally, if you just Google Ryan Mahoney Lawyer, you will find me. And we can talk. I can do whatever I can to keep you protected and shielded. But never be afraid to help someone out there that you know has been hurt.
And I think the thing to remember, everyone, is that if you saw anything weird, anything, you might as well just share it, because you might have second guessed yourself. Is that what I really saw? Is that what? But you know what? Just let the team know, and they can either do further investigation or add it to their list. And you never know where it would lead.
We all learn from a very young age, red light touch, green light touch, right? We're taught this from day one. You see anything that you think an adult should not be doing to a child, not saying to a child, that's the information we need.
Yeah. Well, thank you, Ryan, for sharing your wisdom with us today and your experience. We'll put all of your information in the show notes and description box and all that fun stuff. Reach out to Ryan if you are interested in potentially, if you're in Illinois, I guess I would say you're most likely Illinois, but have your own case that you're interested in pursuing, or if you have any information on Rachel's case, we'd appreciate any and all support. So,
well, and I'll point out, I do this across the nation, and if I can't handle your case, I have partners that can.
Perfect.
We have connections all over the U.S., so don't be afraid. We'll help.
Perfect. That's awesome. Well, thank you again, Ryan. You guys have an amazing day, and we will see you next week.
All right. Thank you.
Thank you so much for listening to this powerful episode of Stop Suffering in Silence. If you are interested in booking Rachel to speak at your school, your church, or on your podcast, then please email openblindeyes@protonmail.com. If you are interested in sponsoring a survivor on their healing journey and would like to donate to Stop SIS, then please check out the link in the description box or show notes below, or you can email stopsis@protonmail.com. And finally, if you are currently suffering in silence, or you know somebody who is, whether they're dealing with a current trauma or one from the past, then we will always recommend that you reach out to your local resources and find a counselor that you can trust, because nobody is meant to suffer alone. Have an amazing week, and thank you for being here.